All right, it is 11:01. I'm going to call the subcommittee work session on HB 313 to order, and we're going to start the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. For all. All right. So we are here to discuss HB 313. If the committee remembers correctly, this was a bill that we had retained because, to be honest, I personally did not have the bandwidth at the time to work through the details. And I think now that we have had summer break, we have the opportunity to look at this with fresh eyes. So I'm hoping, first of all, to allow members of the public to speak if they have some things to add or contribute to this work session, and then committee members as well. So I don't know how the committee wants to start.
Let's hear from the public. And then
Yeah, let's start with the public. So is there anyone from the public that wants to speak on this bill? Come on up. Yeah, that's his proposal. All right, just Phil, if you could introduce yourself.
Yep.
Yeah, my name's Phil Giroux. I'm from Goffstown, and I'm interested in this bill personally. And I've made testimony on that earlier, so I'm not going to repeat it. I was given a proposal written, and I do not agree with it. Because first it says, if any action will be taken against a person, that contradicts the intention of the statute. Matters which, if discussed in public, would likely affect adversely the reputation of any person.
So let me interrupt you.
Yeah.
I had floated around a amendment with another member of this committee, a Republican. So we had talked about this.
Yeah.
We have a proposal. We don't know where we're going to go with that. It hasn't even been brought up or introduced. And
Okay.
I didn't want to blindside another member of the committee. So
Oh.
with that, can you talk to me about what you are looking to do with this bill? What are your main goals?
My main goal is to clarify it, because there's been a battle going on, and what I'm trying to prevent, because in my situation, what happened was I was arrested, prevented from attending a closed session, which basically I requested, and I was told it's small town politics. And now my question on that one, or my concerns on that, is because I'm arrested and these people are allowed to go into a closed session when the police don't even take any statements from these people before they go into a closed session. What's preventing them from just collaborating a story, considering it was the chief's wife that was holding this closed session? And I was told it was small town politics, and I can get into that if you want, but I'd rather keep to this. But
Go ahead, Representative Kuto.
go ahead.
Thank you, and thank you for taking my question. I
Yeah.
just wanted to clarify. So what you're saying is that you requested a non-public session to,
Not necessarily non-public. I just wanted a meeting between myself, the selectmen, and the community center people. And I was told they had no jurisdiction whatsoever, and I was pushed aside, and then I found out they were having a closed session, and I showed up and I was arrested. I did have a sign on my truck, but that was freedom of speech.
so was the non-public that you requested something that might affect your reputation?
No, because I was asking them to address the well that supplies the community center and the town hall at the time, because they weren't monitoring it, and it only sat like 100, 200 feet right in the middle of the two septic systems, which your laws say you need 400-foot diameter. And now when I was arrested, they just ignored all that, and while I had bail conditions keeping me from even driving by the town hall, I had to call Department of Environmental Services to get this well registered according to law. And the last charges they threw on me, well, they were vacated. And I was in jail at that point because they were able to actually get my bail revoked. And I'm sitting in jail for 21 days on a hunger strike, living on water. And they're handing me these fake new charges. And I'm sitting in your courts going, who is this alleged victim? and nobody's telling me I'm found guilty.
Okay, so yeah, go ahead.
But in the meantime, on that one,
I want to get back
yeah,
to
but back to the well.
Bill,
In the meantime,
I want
okay,
to
go
get
ahead.
back to the
Yeah,
bill.
Yeah.
The bill as written is giving us an avenue to request a meeting be public if your reputation was discussed. So your situation, you were not specifically discussed in that non-public meeting.
yes, I was.
Well, can I follow?
Go ahead.
'Cause I think
Yep.
so it sounds like the meeting that you requested shouldn't have been non-public. And then because they made it non-public, then you're subsequently, before you were arrested, they made that non-public to discuss it.
No,
I'm just
no,
trying to
no. Wait a
understand
minute,
where
wait a minute.
non-public came in.
They told me they had no jurisdiction to hear the case. They dismissed me. Then later on, I found out, which according to the testimonies, the selectmen have testified. Oh no, it was the community center people that just walked in, but the community center people, I have testimony on this, written testimony, and they're saying, oh no, the selectmen requested the meeting. So they can't even decide on who requested this meeting. But yet they told me there was no jurisdiction to hear it, pushed me aside, and then scheduled this closed session that they were planning to have. And that's written in the alleged victim's testimony, because she says I was not going to be allowed to attend this meeting. Even I have a deposition from Sergeant Diagnald because they tried to make this big thing because I was supposed to be bringing this gun to this town hall, which is a bunch of bull. And you know what? In his testimony, he said the gun had nothing to do with it. We just didn't want you to get in the town hall.
Okay.
So, I mean, that was a bunch of bull. They just didn't want me to attend this meeting.
We're trying to, yeah, what we're trying to do,
Yeah.
not specific of your situation.
Yeah, but this is what I'm trying to prevent.
I understand. You're asking, the reason this bill was filed is that you believe that if you're being discussed in non-public, you have the right to attend the meeting, and have the opportunity to request an open meeting.
Yes,
And if you request the open meeting, that shall be granted.
correct.
That's what you want.
Well, that would be preferable, but then Rep. Lynn has argued about the investigations, and I looked at the licensing board. I looked at the New Hampshire Attorney Discipline Office. I looked at the New Hampshire Attorney General's law enforcement manual on these things, and I don't want to interfere with any investigations. So, I mean, if these closed sessions are going to be involved with it, that's why I wrote my proposal. And basically, what I'm trying to do is say, yes, we need to be notified, other than 4 exceptions. And my 4 exceptions was discussing jurisdictional issues where no evidence or information or testimony of any kind will be presented. In other words, if someone goes before a school board and they have a question, it's a vandalism problem. Now, that's a question of jurisdiction on who should investigate that.
Mr. Chair,
Yes.
if I could just
Go ahead.
direct a question, because I see your main points in your
Yeah.
numbers 1 through 3. We're here solely on the issue of opening a non-public session.
Yep.
when reputation is being discussed. It's the only thing we're interested in. We're
Yep.
not interested in jurisdiction issues. We're not
Well-
interested in catching a person. No, that's what I'm saying. We're here for specific.
I'm just saying, I'm not concrete on this. I'm just saying, I looked at the Attorney General's law enforcement manual, the Attorney Discipline Office, and these are the steps that they have in there. And when it comes to it, like I said, it makes sense that the board might want to discuss, do we have jurisdiction to even hold this? Do we have the authority to do this? And if like I was saying, I was trying to use the example of like a school board. Now, do they have the authority or the jurisdiction or the correct jurisdiction to investigate a vandalism, which is a criminal offense? You know, I mean, that's why I'm giving that exemption to open it up. I'm trying to basically make room for like Rep. Lynn's argument about investigations. I don't want to involve or impede investigations. That's why I put that part in there. Okay?
If you can center it around I guess my inclination with this is a person has a right to be notified when they're being spoken about in a meeting.
Correct.
That's what I feel. And maybe this would not be, maybe the committee would, and this is, I'm going to speak to the committee real quick, but maybe this would be something where we shift this over to a simple notification when the meeting's happening, unless it qualifies under a certain like emergency meetings or something like that.
We can discuss what's practical, what's workable, what's philosophically
Yes.
necessary. Yeah,
Okay.
but, you know.
Okay.
perhaps
So
he
I'm
should
going to ask,
Wind himself up.
yep, if you can wind up Phil and or Mr. Drew and give us the what you're looking for this. I mean, this bill's a simple bill. It's 5
It
lines. So give
should
me,
be, but the one thing that people seem to forget, it's a closed session. You can seal these records. You can now have allegations about a
we
person
can
in those.
deal with the record sealing.
But I'm
in
just
this bill,
saying,
too.
this is what the situation is. And then 10 years later, they could be unsealed. Try to defend yourself against some 10-year-old accusations. Let's say
Yeah.
I decide to go for a public office, and all of a sudden they're pulling these fake allegations against you out. How are you going to defend yourself against that?
Okay.
How is the board actually presenting any kind of resemblance of being impartial when they don't even want to notify or even have this person in
Okay.
the discussion?
So I agree with what you're saying. So so what we need to do is, as a committee, this is the feedback I'm getting: notification, and you want the right to unseal the minutes about your meeting or make the meeting public.
Right. I mean, that's what we should be able to do. We
Okay.
got to be notified so we can actually see these meeting minutes. Because to be honest with you, the meeting minutes that I got from the courts after the town told me, oh, they weren't prepared. Well, then they mysteriously presented them in the courts and had them sealed so I couldn't see them. And then I found them in their public records. They're talking about me stalking and harassing and having this unhealthy attraction to this director.
All right.
You know
So
what?
at
2
this
days
point-
after, no,
Phil,
2 days
Mr.
after
Drew,
this
Mr. Drew,
arrest,
at this point-
the director is
Excuse me.
contradicting
Hello.
your statement.
I'm asking you to be in order. We understand what you're looking for. Okay.
Yep.
So with that, I'm going to ask that you take a seat and we
Okay.
will discuss. And if you have any substantive feedback at that point, I will get to it. Okay.
Okay, I appreciate it because I do not appreciate government officials of slandering a person trying to help
Thank
their
you.
town.
Thank you.
you.
All right. Does anybody else want to speak from the public? Okay. Representative Kutap, go ahead.
Is this, are we kind of speaking like
Yep, speak freely.
informally? Okay.
Yep.
So I guess my thought would be like two things. So one, under section C, it says all discussions held and discussions made during non-public sessions shall be confined to matters set out in the motion. It sounds like part of the issue is that, I guess not even just from the previous witness that we just heard from, but from others, is that these are being turned into sessions where they're just being made non-public for the purposes just of gossiping about people. Could we clarify that after where it says confined to the matters set out in the
Where's
motion?
that? I don't see that in the bill.
That's sorry, that I'm over in 91A3
Oh, you
I
pointed back to the
C.
statute.
Yeah.
Which I don't have in front of me.
I could ask for it to be printed so we could all look at it.
Sure, but if you're going to discuss changing other sections to the statute.
I just think it would make
probably
sense
be
because
necessary.
then we could put, and the motion may only be made if the matters to be discussed are within the authority of the board to act. Because if you're not going to be, if they're just gossiping about things that they don't even have the authority to even act on, then why are they using a non-public forum for that, right? If they want to gossip outside of the meeting, there's nothing we can do to prevent that. However, I do see the point. If you're using a whole body, somebody's there to take minutes, and sometimes these people are paid to take minutes. Why are we using resources just to have gossip hour?
Well, I'm not familiar in the sessions that I've been at that they're gossip hours, but assuming for the point of this, that there are, how is that first of all determined ahead of time? And who determines, other than the chair of whoever is running the meeting, whether something is within the purview of what the meeting is about or not?
I mean, I
How-
think
how does
it
that
would
work?
be the discretion of the chair, and there's not, I mean,
Right. So
there-
can anybody who's, if we're at a school board meeting or a zoning meeting or whatever, and we go into non-public session, and there's 4 or 5 of us in non-public session and a chair. And if it gets into random stuff, I assume anybody can say, Ms. Chair, that's not what we're here for. I mean, do we need to put that in the statute?
So typically, when you go into non-public, you know ahead of time that you're going into non-public
for a yeah,
for a particular purpose. So
right. So if somebody wanders off and starts talking about, I saw somebody at the grocery store and they were buying such and such a magazine. I mean, somebody's going to say that's not what we're here for, and that's what the job of the chair is.
right. So
Why do we put that in the statute?
I don't necessarily think we need to deal with the jurisdictional component with it. Like if it's there, whatever. I think what I want to deal with in this bill is to simply, if you're going into non-public, typically you notify if somebody is going to be brought up in non-public. And barring an emergency meeting under certain components, typically you're going into non-public and you know what the purpose is. So I guess my question, and maybe the municipal association can be an example, but what would be a situation in which you had an emergency meeting where you would need to go into non-public?
I could think,
Like, I'm-
suppose you got a situation where somebody has alleged that a teacher or school counselor has misbehaved in terms of a child. You might want to have a pretty fast meeting.
but wouldn't that be under number A, where
Yeah,
it says
wouldn't-
the dismissal, promotion, compensation of any public employee, or the disciplining of such employee, or the investigation?
So it would
Can
already
be.
fall under existing reasons to have.
Right. Well, you asked for what's the circumstance when
Right.
you would need
No,
to
but-
do it quickly. That's the circumstance we need to do it quickly.
But is there a circumstance for letter C that doesn't fall under the other categories, where this one is just matters which, if discussed, would adversely affect the reputation of the person? It doesn't meet the criteria for one of the others that are, I mean, I guess I should print this out really quick, because that's probably an impossible question for me to ask you, because there's A through M, and I'm very sure that I don't remember what all of them are. There's
right.
no way that I should expect you to.
I'm assuming for our discussion here, we're talking about the section about the reputation,
Right.
where
Yes.
the reputation of somebody may be brought up.
Yes.
And or adversely affected. And there's 2 Supreme Court cases that go directly into what that means and what it doesn't mean. Actually, it's a very narrow concept. So I thought what we would be, and I haven't seen any other proposals, I thought what we were talking about was under what circumstances, when a non-public meeting is discussing the reputation of one or more persons, that a person has a right to say, I want this out in the open, I don't want it in a closed process. That's what I thought we were talking about. I see a lot of problems with that, and I thought we would be discussing that. But I thought that is at least what we're talking about.
I think that
That's what the bill
where
is.
I
It is.
understand, and I think
Discussing the bill.
this bill
Yeah.
almost takes too big of a bite at the apple, and I think maybe if we center it around simple notification and request the meeting be open, you don't necessarily have a right to attend the meeting. I don't think that
Right.
that's what the bill says, but if we want to scale it back and just say you have a right to be notified and you have a right to say it's public, I'm okay with something like that, because I think that goes to at least address the issues. So if there is a reputation
Okay.
issue, you could go back and address it with the video clip or whatever.
In the simplest context, yes, that is probably unobjectionable. The proof of the pudding, though, is in the eating. So let's say you've got a grievance kind of situation, and the board, for whatever group or organization, knows it's going to go discuss that in non-public session, and they know it's going to involve employee Smith. okay? If it's the simplest possible thing, they know that's what it's going to be. They know the person's going to be discussed, and they let Smith know. They go into non-public, and Smith says, "I want this to be public." Right. Okay. What happens if in the middle of that hearing, another Smith says, "It wasn't me. It was that louse Jones. And it's Jones's fault. I only responded to what Jones was doing, et cetera, et cetera." At that point, do you stop and give Jones notice that his reputation may be adversely affected and he has a right to make it public? What happens if Jones says, "No, it's affecting my reputation. I want it private," and Smith says, "It's affecting my reputation and I want it public"? What do you do then? What if you do in a situation where there's a child involved and the statutes or other reasons to protect confidentiality of children, or victims, or you can go through it? So it's not just the simple scenario where the only name that's going to be mentioned in this hearing is Smith, because you don't know. And when another name comes up, you have to stop everything and, reconvene in a week or so and the like. And then you have another hearing and another name comes up. What if there's 3 people going to be named? Do you have to have an assent from all 3? I mean, these are the practical problems. If you just look at the simplest, there's only one name and that person wants it public. That's the simple. Now, you can limit the bill and say it only applies when there's one person. But how do you know what's going to come up in a hearing? How do you know in advance? And how do you know during the hearing? These are the kind of things that make me say, I don't know how this can absolutely work in real life. There's a timing thing. The bill says, at which point, and I don't know what the words "at which point" mean. It says, unless such person has a right to attend the meeting. I get that, because you don't have a right to attend all non-public sessions, only if they're going to do something. There's a right to attend the meeting, at which point that person shall be given the opportunity to request. I don't know what those words are. At what point is that? It just doesn't tell me anything. At the point you start the meeting, at the time you call, the name comes up in the private session, or a week before? I have no idea what that means.
Well, and I think that's kind of like, so I think that's why I was making the point about, unless you're even going to be potentially like taking action, if you're just doing this just for gossip hour, that would be, you could fix that in the previous section by just limiting it to that. But then I do think, we could also fix part of what he's saying by saying that they should be notified by email 24 hours in advance, unless it's not reasonably practicable, or they don't have an email address. And I guess we could just say that they shall have a right to attend the meeting, rather than that they shall have a right to make it open to the public, if the concern is that then, there might be 3 people that might end up being discussed, and you have one that wants it public and the other one who doesn't. But if they're going to have action taken against them or whatnot, they should have the right to be there and hear what's being taken. And I think, well, let's say, like, even in the case of like abatements, for example, or whatnot, sure, most boards probably are very professional about it, but what if one board is making things political and they're not being fair
We're
about
talking
it?
reputational here.
But that's part that exists in this. This says this exemption shall extend to any application for assistance or tax abatement or waiver of a fee, fine, or other levy if based on the inability to pay or poverty of the applicant. That's part of this section.
I know, because I see it in the bill.
So
But
what if the town is making it political and they just don't want to help out some poor person
what's
within the-
political?
Well, what if they just don't want to help out some poor person because they just don't like them?
And how would that be determined?
Well, because the
For the
person could,
purpose of making an open meeting?
Some say that happens on zoning boards, but
because the
Okay,
person
so you
could
have
be
a zoning board meeting and somebody says, I want, at the beginning of the meeting, a word has not been said. And somebody says, I want this to be open because it's going to be political and this board hates poor people. How's that going to work?
No, it's if the person is being discussed and they ask for it to be. I would say in there that the person, I see what you're saying about it might not be possible to open it for everybody. I think the person should still be able to be there. If we were going to open it for everybody, then I would say that the person would have to request that the meeting be open prior to the start of the meeting, because it's not practical to in the middle of the meeting say, okay, now I've changed my mind. I want the meeting to be open, because okay, then how do you even take care of the minutes for that, where you half closed, half public?
So even in your assessor one, um, for waiver of a fee. So I want a waiver of a fee and the body wants to go into a non-public session. And so I say ahead of time, I want it open because,
You don't have to say why.
I just want it open because I've applied.
Mhm.
Right. And, or I want to attend just because I applied. So there's far different things. If we're talking about attendance, I'm thinking about how they do proceedings in family court involving children, and which are confidential proceedings. Yet, people are allowed to attend. Those are court proceedings. The court makes it clear that if you say anything anywhere about what happens in this closed session, this confidential proceeding involving children, you can be charged with criminal contempt, and you will be. And that's a big incentive, shall we say, for affected members of the public who have a reason to be there, but also to protect the confidentiality of that kind of proceeding.
what if we pull it back more and just say that they have a right to unseal minutes that concern them, and then you can redact the people that don't want to, or the child, or whatever. So instead of waiting that time period, you have the right to unseal minutes that concern you. You can, once they're drafted, you can tell that, like, if this directly concerns me, I'd like to read it immediately.
And what about the feelings of the child victim who never wants her story or his story out there in the public?
Well, that person wouldn't be personally identified, because
We live in small towns.
I
And
understand what you're saying, but
the alleged offender, so to speak, and it's been reported in the newspaper, et cetera, et cetera. The newspapers will never publish that name or identifiers. But how do you know there's not more? What's going to go on at a hearing is going to be far more detailed. And I don't think anybody would have any problem putting together A and B and
so let's say it doesn't have anything to do with that.
well,
Say we have-
let's say it's a grievance of some sort. Because I'm more interested in the grievance problem than somebody asking for a waiver of a fee. I don't mind that kind of stuff. It makes, who does it harm if the full information comes out? So be it. The board can look good, the board can look bad. The applicant can look good, the applicant can look bad. Don't care about that. But so many of these, where we're talking about affecting reputation, has to, those are conflicting. Applying for a fee is not. But when things affect a reputation, it's usually, I didn't do anything wrong, he did, or I didn't do anything wrong, she did, or whatever. And that's why we're not talking about necessarily protecting the reputation of the specific person who is in front of, to use the language, in front of the board. We're talking about protecting the reputations of others. And that's what this doesn't address. Because somebody might say, yeah, I want everything I said rotten about that person out there, and I got a right to do so. And I want it open. But what do you do about the other person? And that's the fundamental. Yeah, I keep going round and round and round on
Right.
this. And if it's limited, and that's why it's, the stuff that it was limited to before, the assistance or tax abatement, waiver of fee or fine based on inability to pay or poverty of the applicant, none of those are the conflicting. There's no victim in any of those.
Do you know do you happen to remember the court case? I'm trying to find it. I just wanted to see what else it applies to, because I don't see grievance or anything in here. So it would be helpful just to read that court case just to know.
These are the two. One of them is actually a libel case or slander, can't remember which.
Oh, yeah.
And that's my copy.
I'll just write it down and I'll hand this back to you.
And this is language actually from both. The more recent one, Sabengham, I'm not sure I pronounced that right, discussed actually the plaintiff alleges the information disclosed at the public session adversely affects his reputation because it enabled the public to identify the subject of the meeting, the individual discussed, and connect the plaintiff's name to the board policy changes which impacted the public. The Supreme Court, New Hampshire Supreme Court, said it's way too broad. That's not adversely affecting the individual's definition, reputation. So I think there was a reason that the exception is what it is originally, because those are not conflicting. There's no victims, there's no children, there's no other person. But as soon as you start getting into that level, I don't know how you make it work. That's the core. And the only way I think to make it work, which is kind of a really Sisyphus pushing up the rock, is to say this bill, this law shall not include, grievance complaints, shall not include testimony of children, testimony of victims, shall not include. And you just go through a list of 27 things. So I'm not sure at that point whether it's any
What
different.
good it would even do
Yeah, I mean, we already
Right.
have a
than
protection.
the existing. Yeah.
We already have a protection for the assistance of waivers and abatements and the like. We already have it. What we want to add are these ones that the legislature has refused to do in the past.
I'm inclined to agree with you. You've raised some interesting points, so I guess I'm. What do you think?
Well, I'm wondering if there's a way, he has raised some really good points, but I'm still wondering if there's a way to meet in the middle so that the person can attend the meeting to hear what's going on. And
And how do you keep,
If the meeting is just about that person, then I don't see why they, it would need to be, oh, well, you can't discuss anything that was said at the meeting. But if the meeting involves more than one person, I do see his point about saying that you have to keep it confidential, just like family court does, because, or if it involves a minor child, because I do still think there is that point that that child should have some right to keep their information private, and just because the parent.
So we can narrow. So, Representative Birch, we narrow it down to one person, right?
how do you do
If
that
a
in
meeting,
advance of the
if a
hearing?
meeting is called in advance, and it concerns one person, right? Like if it's
Yeah.
about like a singular issue, then they have a right to be notified.
And I
And
think we
it's
could
in-
make it say
but-
just via email, 24 hours in advance, unless it's not reasonably practical to obtain their email. Because I do see the point of, we're not going to send out, we're not going to send out certified letters to people and get into all of that. But if you're going to be talking about somebody, you have their email. Like,
Well,
pretty much everybody.
The mechanics, I don't care about, that can be done. Question is you're asking the board to know ahead of time whether only one name is going to be discussed. And you just don't know. We could have somebody here who, as soon as they get started, starts listing a whole lot of grievances or a whole lot of thoughts or a whole lot of people's names. So there's no mechanism of what to do when that happens.
But what if we said if it is just one person, then,
How do you know?
oh, no, I know, but at the time of the meeting, you're going to know after the meeting. If it's just one person, that person can disclose what happened. If it involves multiple people, then they can't. We handle it like family court, that we're not going to let them disclose what happened at the meeting.
Well, it doesn't have authority of the court behind it. How do you keep them from doing it?
I mean, it's in the same way that how do you keep the board from actually notifying the person? Because that's going to be sealed up in non-public, and it's not going to have the person's name on it. So it's
Well,
going to be kind of the honor system on both sides.
so if I'm, a 13-year-old person who's been abused, and the abuser is going to go in and have access to everything that I have said, and we're going to have an honor system that person is not going to wrongfully disclose. I could
Why would
sign on to
abuse be
that.
discussed at a?
Suppose you want to fire that employee.
Okay,
That
but
would
what
be
if we
covered
take
under-
what if we take things that are like what if we take, like, I guess that would fall under state things. What if we make it just related to political subdivisions? I see what you're saying about state actions, because then that could get into YDC things and all kinds of other
All right,
things.
so let's say you've got somebody at school board, and the allegation is that the person stole a lot of money. Now, granted, there may be, investigation on the criminal end and things like that, but you got a school board thing, does this person still operate as treasurer? The person goes in and says, oh, Jane Smith told me you had free access to such and such. Well, what do you do then?
So that's already an existing right for them to waive non-public, though, if it's about an employee of the school.
Pardon?
A personnel, they can waive their right to confidentiality to begin with. Right. So I think
Right.
if a board is discussing an employee of the district,
Yeah.
they already have the right to be at the meeting and to waive the confidentiality.
Even if others are brought into it.
Yeah, I believe they do. So I think what we need to do is,
Yeah,
I think what we're doing is affording the same right that employees of a political subdivision have.
And the public has that right. Why?
I think they should have that right. I think that's a question for us policymakers. Should they have the same rights that public employees have?
Do we have any?
I'm gonna.
I was wondering whether
yeah,
anybody from the municipal association or whatever has some thoughts.
Is there anyone here from the municipal association or that would like to speak to that?
Or other. or other interested group.
Other interested groups. We're talking about giving the public the same rights as like existing employees have in a political subdivision. The right to waive their
So the existing
confidentiality.
employee has the right to, if the disciplining of such employee or the investigation of charges against him, unless the employee affected has a right to a meeting and requests that the meeting be open, in which case the request shall be granted.
So I want to back up for 1 second because I think I can come up with an example because I
Okay.
think we're struggling with personnel versus reputational. So I'm hoping that this maybe is a better example. Instead of, because if you notice in the section on personnel, right, it's public employees. So let's take into consideration that my elected town clerk is doing something that they're not supposed to. So my select board has to start an investigation, embezzlement. I'm not, something bad. That wouldn't fall under personnel because that person is not a public employee technically.
Right.
So it would have to be discussed under reputation in non-public session, because to start the investigation, you wouldn't necessarily have a public hearing, as is like on removal of like zoning board appeals, ZBA members, you have a public hearing on. Likely you'd have a public hearing, obviously, if this went farther. But in the initial stages, first, like that town clerk, you'd want to have it in non-public session. I think that's a better example than trying to intermingle what a public employee would look like and whatnot. So I think that would require non-public session. So the question becomes, in that non-public session where the select board is talking about hiring an investigator to investigate or accountant to do accountant stuff, would you want that individual to be notified of that hearing?
You would want them
Yeah.
to know how the investigation is going against them.
Well, no,
Or start
You
it,
would-
or
you would-
just
you
merely
would-
start
I mean,
it?
no,
I'm sorry,
we-
I didn't need to ask that question. It was rhetorical.
But I'm asking.
Okay.
No, I mean, I think we could have an exemption in there for it shall not include the initiation of an inquiry or an investigation, because we're not trying to mess up an potential investigation, right? Like, that is the point, that we don't want an investigation to potentially be contaminated, that portion.
So with that, can you ask in terms of that example, does that help with with notification? Because we're looking at, my assumption is you're looking at notification of individuals and who is entitled. I think the same thing that Representative Birch has said continues to apply is even in this situation where you have a town clerk who, potentially is, an investigation. So it's that person gets notified and says, hey, I want this to be public. But then that town clerk starts bringing up other maybe elected officials, maybe members of the public. Hey, well, Representative Birch is helping me do this, or Representative Alexander is bringing this, and that's in the public. So then it becomes, again, we're back to what sort of we've been talking a lot about all along. Who can ask for that open meeting? Because it starts with the clerk asking for the open meeting who's being investigated. But then if there's more people involved, then what if they don't want that out in the public? Maybe the person wants it in the public and is just flailing and naming names off. And those people's reputations, you can't take it back after public session. So, I mean, I think that's where there's concern is, I hear what Representative Kutab's saying. We definitely don't endorse any governing body having a session on gossip session. Do that outside, do that in another place. That's not what this is meant for. Non-public session for reputation is meant to have those discussions about issues that need to be discussed in front of the board, but people may not want to have discussed in public. Local welfare applicants may not want their status as needing assistance talked about in the public. I don't know if that answered your question, but I was trying to help with an example that might be would stay out of the personnel bucket. do you
I
need?
could throw another,
Yeah, thank you. I'll second.
You're welcome.
I could,
One second.
I could throw another concept in there. I don't know if I like it or not, but just, it occurred to me that, if we allow some kind of attendance, should we allow the attendance for the entire hearing? Or only the portion of the hearing that may have to do with that specific individual and his or her reputation? Just to limit the damage kind of stuff.
Okay. Mr. Drew, I'll let you speak again. I just need you to keep it succinct, respectful, please. If you have anything to reply to anything we've been saying.
Okay. First off, I'd like to say that, I mean, there's a lot of talk, and I do see your concern when there's more than one person involved with this. But are closed sessions really used for investigations? They may be used to decide to initiate an investigation. It may be decided to maybe catch a person in an act, or maybe submit a subpoena to collect evidence and stuff. But when you go into a closed session or at this public meeting, that information should already be forwarded, and you should already have most of it. And hopefully, because according to the Attorney General's law enforcement manual, under the 14th Amendment, the investigator is required to talk to the accused person. So, I mean, they should have been talking to this person, and if he is going to be pointing his finger at somebody else, well, then they should be going to talk to them too, and they should already be aware of this before they're even going into the public session or the closed session, to me. I mean, I could be wrong, but that's how I'm looking at it. I mean, I know I don't have the experience being in the closed sessions, but this is what I'm seeing. Why are you calling this person in at this point to try to get questions from them and drilling them at that point? You know, your investigation's already supposed to be an open, or impartial. And that's my point is, unless it's going to disturb evidence being collected or something like that, or determining jurisdictional issues, or even starting an investigation, why aren't we involved in this? You go to the attorney discipline office, you file a complaint. First thing they tell you is you have to file and send a copy to the attorney you're complaining against. I mean, that's how it is. But yet, when it comes to these public sessions, we're not supposed to be known about it. We're not supposed to be told. They're trying to keep us out of it. That's not right. And when you come to what rights we have, I would say that comes under the defamation tort clause, the old defamation tort laws, and the 14th Amendment. Where's your impartiality? Where's even the sign of any impartiality when you're keeping the accused out of the victim, out of the thing?
Suggestion. If I want to put in an ethics complaint against my friend Representative Alexander,
Yep.
I go to the ethics board, I file a complaint.
Mhm.
They will either have me send it to him or his attorney, or they will send it. I don't know.
Yeah. But either way, he's notified.
Anyway, that's done. It is not public. There's no right to the public.
And that's where
So
the attorney
we just
discipline
start
office.
right there, just because parties may be required to,
Unless it's waived.
at a later stage.
No,
Okay, or maybe at the beginning.
you have I believe if you're talking house ethics, the member has a right to waive their confidentiality at the beginning of the investigation.
First, they have to determine, I think, whether there's going to be an investigation, just preliminary stage.
Yeah, and I
in
know
but they have a right to
Yeah.
reveal the complaint lodged against
Right.
them.
Yeah, because even in the attorney discipline office, it's probably the same thing. They file the complaint, you file it to them, they get both answers back, then they go in the office to decide, do they go forward?
Right.
I mean, at that point, nothing's basically public.
Right.
Okay.
So, I mean, that's fine, and that's where I had it in my bill, that section's fine. I mean, I have no problems as long as but then I'm concerned because like in the liquor license board, they can have all this evidence here, but it's only the evidence they're presenting that go at the closed session that's actually public. I mean, that's how the statutes are written. So, I mean, you got situations like that. But like I said, my main concern is when they're using it just to slander you. And like you said, in a small town, all you have to do is just say it was a closed session about me, he was arrested. That's it. You're slandered. Believe me, I was slandered.
Okay.
So I'll
Thank
leave
you.
it at that. And
Thank you.
and one more other point I'd like to make, I do not agree with that email situation. Because we all don't have emails. I have an email, I don't check it all the time. I'm checking my work email. I don't check my personal email maybe once a week, if that.
Yeah. Okay.
So, I mean, I'm sure there's a lot of people like that, so I don't think that's practical in notifying people. So I'm just letting that know in a 24-hour notice, that's awful short too, so.
Thank you.
So
All
if
right.
we're-
So we're wrapping up on an hour. I said an hour. Promise.
I think I do have a solution, although the notification piece we can discuss more, but can I just
Go ahead.
propose it? Okay. So the person shall be notified, just gonna say it for now, via email at least 24 hours in advance unless it is not reasonably practicable to obtain their email address or they do not have one, and they shall have a right to attend the meeting. Nothing in this section shall require a meeting to be rescheduled if the person is unable to attend. Notification shall not be required for the initiation of an inquiry or an investigation. It shall be unlawful for any person present during a non-public session to disclose any information that may identify any other involved parties without their written consent. Any person who knowingly violates this provision shall be guilty of a violation. And that's the same language that was taken from RSA 169C25.
So I didn't catch too well the last part. If you're suggesting that, does this have to do with an individual who attends this non-public session because he or she's reputation may be adversely affected, and they mention someone else's name? Is that what you're talking about?
Yeah, so if it involves multiple other parties,
What happens?
then they cannot request, so it shall be unlawful for any person present during a non-public session to disclose any information that may identify any other involved parties without their written consent.
So you're the guy. You come into the hearing and it's explained you're here because of some bad thing you may have done in some manner. And let's say I'm the guy and I say, no, actually I was told by, oh, you better stop. You can't say another person's name or you're going to be prosecuted. That doesn't
No, you
make
can
any
say the
sense.
name,
You
but
can say it, but you just can't disclose it from outside of the non-public session.
So you say whatever you want, but you can't disclose any name outside, but you can disclose everything else. You can say, the person is a state rep. He comes from Westmoreland. He's short but handsome, and he wears funny ties. But I can't mention his name. Is that going to work?
Well, so the way that it words it in here is disclose, so I could word it a little bit better, I guess. It says disclose any information that may identify the person. So we could say,
Oh, if I were a defense lawyer, I could, whatever my client said, I could say, no, that didn't tend to.
but that's how the court does it in the family court. That's exactly how it's worded in the family court
I
piece.
understand that. I also know what judges say in the open courtroom about you keep your mouth shut 100%, period, etc. But, yeah, that may go as far as, your standard as Representative Alexander started with one person going in. What happens if you know ahead of time it's going to involve several names? And two of them want it closed and one of them want it
This
open.
isn't allowing it to be public. This is just saying that they'll have the right to attend the meeting. It's
Right
not
to
saying that they have
attend.
the right to make it open to the public, because to your point,
Okay.
what do you do if there is 3 parties involved and one party wants it public and the other 2 don't? I get that, but the person should at least be allowed to be there.
Is there exception when the Attorney General's office says that any disclosure to a potential defendant is going to harm our investigation of the case?
I'd be happy to put something in there. I did say in there that notification shall not be required for the initiation of an inquiry or an investigation. So I think it's making it more difficult when you consider things on a state level than you are at a political subdivision level. So I don't know if we want to make this really apply to political subdivisions rather than at a state level, because I do see at a state level it is really complex, especially when you involve like the YDC cases and whatnot. And I don't think for the purposes of what has otherwise been mentioned, it really was for the political subdivisions, the towns, the school districts. That's really what people are asking for, not really.
But a
at the state
YDC type case can come up at your local level. That's the problem, is it can. And it's not necessarily that the board itself may be opening an investigation, a formal investigation. It has to do with whether some other body may be opening or has opened. And the consequences of that board having to fill in that future defendant on facts that the Attorney General's office or the local county prosecutor may not want that person to know those facts.
Well, I mean, I'd be fine with putting in something about, you know, you wouldn't have to do this if it was going to hinder an investigation.
So I'm trying to save some part of this bill, but part of me is also thinking like you poked enough holes in it, Representative Birch, that I don't know how much what can be saved with this. So I guess we have an exec coming up in Judiciary. I think if we want, yeah, I will let Representative Kutab do some more research in this and make a proposal, and maybe we'll meet before the exec. We actually probably should meet before the exec and make a recommendation. But I don't see a reason to have us come another day unless we're here for something else as well. So,
Yeah. I mean, I can talk the politics of this. I don't see this going anywhere.
I know our friends on the other side of the wall don't typically pass our right to know stuff, but
So you don't think even
I don't think our committee will go for this.
So you don't think with the language that I was just suggesting, if we kind of tidied it up a bit about not hindering an investigation, you don't think that that would be something that you could support?
Well, once you get into, before the hearing is even set, you're going to have to decide whether it's going to hinder investigation. What does that mean? You call up the county attorney's office and say, if we held such a hearing, would that be problematic? And probably 100% of the time they'll say yes, because they're careful and cautious people, and they don't want to do anything that's going to screw up their investigation.
But then why is the body talking about it if it's supposed to be so?
Because the body may have to take some action as to a current employee or whatever, without sitting there telling necessarily chapter and verse of everything.
okay. So with that, I actually just got an email. I want to welcome Representative Kevin Scully to Judiciary. Welcome. As a permanent member of the committee, do you have anything to contribute on this? Great. Sounds good. So welcome
you're
to
a new member of-
Judiciary. He's replacing Representative Morton.
Oh, okay. Well, welcome. Yeah,
So
we're normally friendlier than this.
this is friendly. What are you talking about? He just doesn't want to sit next to me anymore.
I know.
All right. So with that, I'm going to close the work session and have a next meeting to be determined. No action has been taken by the subcommittee today. Okay, great. Thank you, everyone.